All right, well, it is 3:30. I think it's time for us to get started. Good afternoon, everyone. I'm Eric Kasper, the director of the UW-Eau Menard Center for Constitutional Studies. I'd like to welcome you all here for Plague, Power, and Policy, Lawmaking in a Pandemic. This event is co-sponsored by the UW-Madison Center for the Study of Liberal Democracy. Our panel here deals with some pretty profound questions. We have, of course, as I think we're all well aware, and we've all lived through for more than a year, the COVID-19 pandemic, which itself has renewed ongoing questions about government power and constitutional liberties. Today, we have a panel to hopefully give us a spirited discussion of where the line is between the government's emergency authority to protect public health and the rights of individuals, business owners, and organizations. Now we'll proceed here with some introductions of our panelists who will each then offer their thoughts on these matters. And then we'll open it up to questions. And toward the bottom of your screen, there is a Q&A feature. And you can use that as we go along here to type up questions that we'll ask to our panelists after we've heard initial comments from each of them. So our panelists today include the following. First, we'll have Howard Schwaber, who is a professor of political science and an affiliate member of the UW Law School and the Integrated Liberal Studies program at UW-Madison. Prior to receiving his PhD from Cornell University, Professor Schwaber practiced law for several years. He is the author or co-editor of 6 books and numerous articles dealing with a range of issues related to constitutional law and theory. He is also the editor of Constitutional Studies. Now, as far as as a preview here for what Professor Schwaber will be telling us here this afternoon, it would be as follows. He says that the question of what kinds of powers the national or state governments can properly exercise during an emergency is as old as the Constitution itself. Wars, natural disasters, and pandemics were all familiar dangers in the founding era, and discussions of the authority of government at different levels to impose quarantines, require vaccinations, and take a range of other public health measures are discussed at length in Supreme Court cases. The questions are not only about what kinds of emergency powers are acceptable, but also who should exercise them and how they should be exercised. Professor Schwaber's talk will briefly review some of the history of these issues in order to provide a historical and legal context for the other panelists' presentations. After Professor Schwaber, we will have Rick Esenberg, who is the founder and current president and general counsel of the Wisconsin Institute for Law and Liberty, which is a rapidly expanding law and policy organization headquartered in Milwaukee. Now, Rick Esenberg has the following for us in terms of a summary of what he'll discuss. He says that the COVID pandemic brought about extraordinary restrictions on both individual and organizational liberty. However one feels about any particular restriction, the risk of abuse and normalization of such restraints was something that policymakers and courts needed to recognize. He goes on to say that structural limits on the authority of government, as opposed to liberty claims, provided one avenue for doing this. And our third panelist is Kaylee Murray, who is a professor of law at Marquette University. Professor Murray's research agenda is focused on the politics of participation in patent, property, and administrative law. Her work on patent law focuses on a range of issues, including the impact of different administrative actors, the importance of the patent civil society's ability to participate in patent law, and the emergence of a heterogeneous policy environment. Now, for Professor Murray, she will speak to the current debate over Wisconsin's public health regulation, which is in many ways a microcosm of a larger debate over administrative authority at the national level. As Rick Esenberg notes, administrative law at both the federal and state levels is taking a structural turn. As Professor Murray then discusses, notably, this structural turn presents a challenge to pre-existing conceptions of legitimacy of the administrative state, which has typically relied on the expertise of the agency. The structural turn, though, presents significant challenges, Professor Murray will argue, as during the pandemic, we have both at the national and state level, the legislature being unable to function as it should, she argues, due to partisanship. So that is, again, a preview of what we'll hear from each of these panelists. And so to get us started, we have Howard Schwaber.
Thank you, Eric. Welcome, everyone. So as Eric said, or Professor Kasper, excuse me, said, I'll be doing a little bit of historical background to try and give some context for the more substantive and focused comments of my two colleagues. I want to suggest that we think about this discussion in terms of the meeting of two concepts, emergencies and separation of powers. And each of these concepts has, in a sense, a history. So let me talk about emergencies first. We tend perhaps to think about emergencies in terms of big national events in the modern setting, but the idea of emergencies and emergency powers and emergency actions by government goes back through the English common law, the medieval period, all the way into ancient times. Particularly in the medieval and early modern periods, during times of plague, for example, it was entirely acceptable and understandable that villages could be isolated by interdiction so no one could get out. Houses could be burned, cities could be closed to travel. And the term lazaretto was formed in Italy to describe buildings or sometimes even colonies in which people thought to be infected were isolated, locked in forcibly until they either died or demonstrated that they'd been healed. Quarantines become common starting in the 14th century. Orders either restraining people to staying in cities or more often barring people from outside from entering, particularly ships. If we flash forward to colonial America, all of these measures were very well known and very well recognized in English common law as appropriate responses to outbreaks of disease, partly, of course, because the technological responses to disease were very limited, or rather they weren't limited, but they were very ineffective. So destruction of tainted property, quarantines, what we now call social distancing, these were the measures that were available and they were used widely. And the background point to all that is none of that was special to emergencies. In the feudal era and right up to the common law era, the assumption was that local authorities had the authority to govern essentially all aspects of life for the common good. The phrase health, welfare, safety, and morals is most commonly used to capture the term police powers. And certainly in English common law and colonial America, it was not at all uncommon for state level and local level authorities to intervene in private life and economic affairs in ways that we frankly would find utterly unacceptable in the modern era. These problems dealing with outbreaks continued through the 19th century, particularly in smallpox and cholera outbreaks, and they helped shape American thinking about separation of powers. So let me switch gears now for a second and talk about that. Right? So there's a long history of dealing with emergencies, and specifically medical emergencies, pandemics. And there's a long history of recognizing that extraordinary measures may be called for. And there's a general historical tendency to assume that pretty much anything goes. That changes in at least one way when we get to the American founding and the beginning of the American Constitution, not so much in terms of the question of what powers can be exercised, but how they can be exercised and by whom. The American framers, after all, were extremely familiar with emergencies. To take just one example of the three types that I mentioned, that were mentioned in my introductory comments: wars, natural disasters, and pandemics. If you look in the constitutional debates, there are lots of references to the French Indian Wars of 1760s, the Great Lisbon Earthquake of 1755, and any number of yellow fever outbreaks. And there was no doubt in the debates that there would need to be forms of government effective in responding to these conditions, locally as well as nationally. Now, the early constitutional debates were, of course, primarily about forming the national government. The assumption was that these would be problems that would be dealt with at the state and local level. But the idea of separation of powers was already present in almost all of the state constitutions adopted after 1776 and provided a background, the discussion of separation of powers in the Congress. And these are the famous debates which Hamilton insists that the executive needs to have dispatch to respond to emergency conditions. And his critics contend that no, it is critical that the legislature maintain control over measures so that, if I can steal a phrase from Esenberg, who's going to speak next, emergency measures not become normalized. To quote a Supreme Court justice, the framers well understood that emergency powers tend to beget emergencies. Governments claim to have special authority during emergencies, they may be more inclined to declare that they've happened. And so part of the separation of powers argument was between, on the one hand, people who felt that what was necessary was the strongest, most effective, most active possible executive as the branch that would take immediate action. An argument, an idea that got perhaps its strongest expression in Andrew Jackson's theory of the unitary executive, That's the theory that the entirety of the executive branch of government answers to one person, the president. That's so that the president can be held accountable for their actions, and also the president can assert complete control over everything they do. And the early arguments in favor of that role, there were lots of them, but some of them focused on the ability to respond to emergencies. And it's important, I think, to recognize that the ability to respond to emergencies and the question of what approach to separation of powers would be adequate to deal with emergencies was not separate from general questions about separation of powers. So, for example, the question of separation of powers was closely tied up with appointment and removal powers during the Washington administration. Right away after the adoption of the Constitution, it was noticed that while provision was made for how cabinet officers should be appointed, no provision was made for how they should be removed. Madison said this was simply an oversight, but the result was a long debate in the Congress about who should have authority and to what extent the executive should be completely in control of events, particularly during emergencies or wartime or similar situations, and to what extent there must always be sharing of authority so that one branch can act as a check on the other. And I believe, well, we haven't seen each other's comments ahead of time, but I believe that Rick Esenberg in particular will talk about the importance in Wisconsin's case and in the Wisconsin system of the Wisconsin legislature acting as a check on the actions of the governor and the way in which the Wisconsin Supreme Court has adopted that view as critical to balancing separation of powers and circumstances of emergencies. As a general matter, I don't want to repeat myself, but let me reiterate, it has always been in American constitutional history well understood that dealing with medical emergencies, health emergencies, are fundamentally state functions. In Gibbon versus Ogden in 1824, when John Marshall was trying to describe quintessential state powers, matters over which the state's authority could not be interfered with by the federal government, quarantine and health measures were among the first things that he pointed to. Jumping ahead, in 1905, the US Supreme Court upheld the authority of the state of Massachusetts to require everyone to get vaccination against smallpox. And in general, the first term in the phrase of police powers is health. During the 1919 flu epidemic, that we probably all heard of as a point of comparison, there were all kinds of closures and restrictions of the sort quite similar, quite familiar to us from this past year. Sporting events were canceled. Yale University canceled all on-campus meetings. In Italy, churches canceled confessions and funerals. Medical historians agree that school closures, bans on mass gatherings, and social distancing measures in 1919 significantly reduced reduced deaths. But that doesn't mean there wasn't considerable controversy. Listen to this description by the NIH of some of the things that happened in 1919 and the public view of those actions. Decisions made by health authorities often seemed focused more on reassuring the public about efforts being made to stop transmission of the virus rather than on actually stopping transmission of the virus. Many measures adopted in many countries disproportionately affected ethnic and marginalized groups. In colonial possessions, restrictions on travel affected the local populations. The role that the media would play in influencing public opinion in the future began to take shape. Newspapers took conflicting positions on health measures and contributed to the spread of panic. So it's not new that there's political controversy over the efforts that are taken in America by both the federal and the state governments to deal with pandemics. And those controversies take place in an environment shaped by media-driven and sometimes partisan discussions on the one hand, and by two very long-standing traditions. The separation of powers debate over whether the executive branch needs to be able to act independently and vigorously in the face of an emergency, and therefore should have direct control over resources without being limited by the legislature, or the countervailing view, that principles of separation of powers are particularly important in times of an emergency, since those are times when an executive is perhaps most likely to seize extraordinary authority, and therefore it is particularly in those times that the legislative branch, or sometimes the judicial branch, needs to act as a check on the executive. And around the country, different state constitutions have different systems of separation of powers for balancing these two concerns. That's one side. And then the other very deeply rooted side of the conversation is an understanding that emergencies like wars and pandemics are threats to everyone. That they are special situations. A person who refuses to engage in social distancing is not so much someone akin, is not so much analogous to going outside without shoes on as to someone dumping poison in a water supply. That is, there's a notion that in the case of a pandemic, how you act affects others directly, and therefore the standards that can be imposed on you have to be higher, because history suggests, history teaches, that nothing less is sufficient to stop this particular kind of emergency. And of course, you can make analogies to responses to natural disasters and to wars. I think this is enough to set up the debates that we're going to be hearing. I actually was not watching the clock, but I believe that was about 10 minutes. And so I will pass the baton, as it were, off to Rick Esenberg. During the question and answer period later, I'll be more than happy to talk about historical events and records or constitutional debates, both early and modern. But for now, with that as an historical setting, let's hear some specific debates about steps that have been taken in the past year. I think with a focus on Wisconsin and how we should think about them in terms of legal and constitutional issues.
All right, and with that, then we will turn it over to Rick Esenberg.
Well, thank you. You know, I come at this from the perspective of a line litigator and one who found himself in the following position last spring. The pandemic began, and the government responded by putting in place what were, to our contemporary sensibilities at least, extraordinary restrictions on liberty. The government told people that they may not leave their home except for one of a specified number of reasons. And a person in my position was almost immediately faced with many demands to do something about this. And but we lived in a time where there was great fear and uncertainty. The COVID pandemic, as it turns out, is quite real, quite deadly. Nobody knew for sure what restrictions were necessary. And I quickly came to the conclusion that a frontal liberty assault on these restrictions would both be unwise and futile. That, as I said many times over the course of the past year, that from the perspective of a litigator, if one moves forward and challenges these restrictions, and as you know, Howard pointed out, there have been challenges in the past, and in general, the government's ability to take measures to control infectious disease has been upheld. Most famously in the 1905 Jacobson case, that if one were to challenge these things and wind up talking epidemiology, you would be losing, right? Particularly in the spring of 2020, because no judge wanted to question whether these restrictions were necessary. No judge wanted to take upon himself or herself the responsibility for what might happen if these restrictions were lifted. So it seemed to us that a better approach to this would be to look at the rule of law and structural limits on the power of the government. That at least under circumstances like this, where we had really two competing values, right? One was the need to do something because we had a pandemic, and the other was a concern that what the government would wind up doing might be overreach because there was a pandemic and people were panicked and people were afraid. And so what happened, I think, was a series of cases which tested the structural ability of the state of Wisconsin. We're talking particularly about Wisconsin here. I think our litigation was very, very well developed here, but it wasn't unique. The same things happened in other states. What were the rules that governed the state response to the pandemic? You'll recall that in March of 2020, the governor declared, as the governor is empowered to do under Chapter 323, a state of emergency. That state of emergency under state law may last for 60 days. During that state of emergency, the governor has extraordinary powers. He can issue any order to protect a person or property. As I said before, the the state of emergency has a time limit. It's 60 days, unless it is extended by a joint resolution of the legislature, and that state of emergency may be rescinded at any time by a joint resolution of the legislature. The state of emergency was issued in March. In mid-March, the stay-at-home order was issued pursuant to that declaration of a state of emergency and some other statutory authority that we'll get to in a moment. But as we got into late April, the governor seemed to recognize that his emergency powers were about to expire, but yet still desired to extend these restrictions as the COVID pandemic certainly had not gone away. So what he attempted to do was look to another statutory source of authority, Chapter 252, which gives the Department of Health Services the power to take certain steps to control infectious disease, and use that statutory authorization to extend his stay-at-home order. The governor, rightly or wrongly, being either unwilling or not expecting the legislature to go along with the extension of his emergency authority. That ultimately led to Wisconsin legislature versus Palm. And the argument there, it wasn't an argument based on a liberty claim. It didn't claim that there was a constitutional right to be free of any particular restriction that was imposed by the Safer at Home order, but it was a structural argument. It was an argument that if the governor was going to act beyond the temporal limits on his ability to declare an emergency, that he must proceed by rulemaking. That the Safer at Home order qualified as a rule under state law, and there's a procedure which is set forth for the making of a rule that involves public notice and comment and an opportunity for legislative oversight. He had not done that, and therefore the Safer at Home order was unlawful. By a 4-3 vote, the Wisconsin Supreme Court accepted those arguments, concluding that the governor was obligated to proceed by rulemaking. Now, note, this was a statutory decision. It wasn't constitutional. To be sure, people like us in particular made an argument that if you did not so limit Chapter 252 authority in the executive branch, there would be a separation of powers, problem, because the legislature would have essentially delegated without direction its authority to the governor, but it was a statutory decision. So we moved through the summer. The governor initially attempted to proceed by rulemaking, but then announced that he did not think that he and the Republican legislature could get together. And so rulemaking stopped. The legislature didn't come up with its own set of proposals. And so we went to the summer with no statewide restrictions. There were local restrictions in place in some places, and I don't think we have time to get into those. But as we got into late August, the governor, I think under continued pressure to do something, in particular to issue a mask mandate, after initially saying that, look, I don't have the authority to do this, my emergency powers have expired. The Supreme Court said what it said in Wisconsin legislature versus Palm. The governor decided to declare a new emergency on July 31st. And the only thing he did really in response to that, there were some minor things, but the only major initiative he took in response to that declaration, in conjunction with that declaration of emergency, was to declare a mask mandate. Now, again, from the perspective of a line litigator, did I care about a mask mandate? Not really. Did I want to litigate this issue in the context of a mask mandate? Not at all. But I was concerned about the notion that the governor could declare emergencies in series arising from the same underlying set of circumstances, because, of course, if you look at the statutory definition of an emergency in the statutes, it's quite capacious. It could be almost anything. It could be climate change. It could be crime. It could be unlawful immigration. And did we want to really establish a precedent? Did we want to normalize the notion that the governor, by identifying a particularly acute problem, could act in this way. Oh, of course, the legislature could have ended the state of emergency at any time, but the legislature was unwilling to do that. They didn't want to take a vote on the declaration of a state of emergency, which would be perceived as a vote on the mask mandate prior to the 2020 fall elections. Now, there were people, including a member of the Wisconsin Supreme Court, who ultimately asked me at oral argument, didn't this mean that there was no problem because the legislature had acquiesced? My response to that was that when you are talking about these separation of power issues, separation of powers and structural limits on the power of government don't exist for the benefit of the people who exercise the power. They are allocations of responsibility which are designed to facilitate better decision-making and restrict liberty. And the fact that the legislature didn't want to act, didn't want to assert its own legislative powers, didn't mean that the executive gets to usurp them. So the legislature not acting, the pandemic continuing, the governor then further extending his emergency powers. Ultimately, the matter was litigated. This was something that, although I had hoped it could be dealt with in some other way, could not be dealt with in some other way. And so we filed a lawsuit, others filed a lawsuit. That case ultimately, that issue was ultimately presented in a case called Fabic versus Evers, which we argued in November of 2020. And a couple of weeks ago, this Wisconsin Supreme Court concluded that no, the governor cannot declare emergencies in series arising from the same underlying set of conditions, and held that the declaration of an emergency and the mask mandate was in fact unlawful. Again, not on constitutional grounds, although the constitutional arguments were made, supporting an argument of constitutional avoidance. You should read the law this way so that there isn't the constitutional problem. But the court, in fact, went off on statutory grounds. And so I don't know whether, there are a couple of other cases pending involving local authority, which again, we don't have time to get into. Hopefully this will be the end of the series of litigations arising from the COVID pandemic, because hopefully we will ultimately come to the end of the pandemic. But for me, the real lesson was the way in which structural limitations on the power of government can act as a means for persons who would otherwise make liberty claims to seek redress or to seek greater participation in the policymaking process. And with that, I will turn things over to Kaylee.
Right, and before we hear from Professor Murray, just a reminder that we have the Q&A function toward the bottom of the screen. So if you do have questions for our panelists, make sure that you make use of that and that you type in your question accordingly. But with that, I will turn it over to Kaylee Murray.
Hi. Just want to start off by saying Rick did an amazing job, because we're all arguing on his ground now. And I think he's certainly set the table for a set of arguments, particularly about Wisconsin administrative law, that have been percolating, but I think have reached fruition within the conversation around COVID-19. So I'm going to talk generally about thinking about how do administrative agencies typically legitimate their behavior, how, again, the Wisconsin Wisconsin litigation has led to, I think, a focus in on an emerging way to see and understand administrative law, a conversation that's happening both at the national and the state level. And then I'm going to turn to, I think, the limits of a structural approach as we understand and think about this particular crisis. So the first thing I think that is always helpful to understand is what Rick, as he was constructing his arguments, had to break down. And what he had to break down, I think, is a fundamental understanding of administrative law as based on expert legitimation. That is, we grant deference to administrators like Secretary of Health Andrea Palm, the deference in their decision-making because they are experts, because as they examined the public health crisis that confronted them in March of 2020, they had the bureaucracy, and they also had the expertise to manage a public health crisis. And that typically, when we think about public health crises, we grant the executive, because they are the expert, a significant amount of deference to issue orders based on the public health crisis. And I think Wisconsin law, up until Wisconsin Tetra Tech, has generally followed an expertise model within the context of administrative law. And indeed, if we look at the early history of Wisconsin statute annotated section 227, it was created and is a precursor to the modern Administrative Procedure Act that was passed by Congress in 1946. And so I would say that Wisconsin administrative law has typically followed this expertise model, often referred to in administrative law as the German model. And for obvious reasons, because of our history, both as a progressive state and because of the influence that immigrants of German descent had on the political culture of Wisconsin, the expert model, I think, really was tied to early administrative law in Wisconsin. Now, I think in the last 5 years or so, we've seen the emergence both at the national and the state level of an administrative law that is focused in on a structural legitimation. That is, administrators and the decisions that they make are legitimated because of the ways in which the executive, legislature, and judiciary exercise their core powers. And I think at a theoretical level and at a practical level, there are concerns with the structural legitimation model, and I would want to walk through them in this particular element of my conversation. So the first primary concern, I think, with the structural legitimation model comes in two ways. The first is, I think, Justice Hagedorn, I think, really aptly discussed in his dissent in Palm, that there is both a separation power principle that is horizontal, right, between the legislative, executive, and judicial branch. But he also noted that there is a separation of power principle in the Constitution that is vertical, right? That is between both the federal government and the state government, right? And we see that vertical axis of power in a number of ways, as Howard discussed. We see that axis as we discuss the traditional police powers that are enjoyed by state governments and that are protected, right, by the 9th Amendment. And as Rick noted in his conversation, I do think there are some issues percolating, right, around the ability of local authorities as they exercise their vertical power, their vertical structural power in their issuance of mass orders. And so when we think about structural legitimation, I do think that Justice Hagedorn's dissent in Palm aptly demonstrates that the conversation is a little bit more complex than the relationship between the legislative, executive, and judicial branches. And indeed, I think in Wisconsin, this is complicated by Wisconsin's own constitutional history, namely that Wisconsin recognizes a fourth branch of government, right? We have a constitutional protection of the fourth branch, right? The Secretary of State, the Treasurer, the Attorney General, and the State Superintendent of Education. And as an administrative law scholar, I think it's a very important tradition, a constitutional tradition indeed, that suggests that when we think about the structural legitimation of a law, that it's not a triad, it may, right, instead be a quarter, or and that was me attempting to make a bad geometry joke. And so to the extent that we have that occur, I think we have a more complex constitutional tradition that has been recognized both by the majority opinion in Tetra Tech, as well as Judges Rebecca Bradley's dissents, both, or not dissents, concurrences both in Palm and the Tavern League case. And so I would complicate Rick's life a little bit and have him think through, what does structural legitimation mean when we actually have a constitutional recognition of the fourth branch itself. The second, I think, challenge of a structural legitimation argument is the question around the role of the legislature. Wisconsin has a very interesting administrative law. I've been staring mightily at Wisconsin statute annotated 22-719, right, which permits the legislature to review issued rules of the executive. And then we can also think about this tradition within the context of the Congressional Review Act, which permits, again, the national legislature to review acts of federal administrative agencies. And it presents, I think, an interesting problem in administrative law. We typically see the legislative role as to delegate authority to the agency. And I think it's an interesting I think, theoretical problem and both a practical problem when we institute legislative review of agencies, primarily because it's hard, I think, for legislatures to do this kind of work. It's fairly technical work, number one. And secondly, it creates, I think, a more difficult response when we're in the middle of a pandemic and we need quick executive action or even quick agency action or indeed quick legislative action to engage in a response. And so when we institute legislative rules over agency action, we lose swiftness. And I think one of the key crises of the way in which Wisconsin has handled this particular problem is by imposing structural legitimation on the entire public health crisis. It may have, in many respects, made our response to the actual public health crisis much more difficult. So, and that goes to the second question. When I read both the Wisconsin Supreme Court's opinions and Palm, Tavernley, I think a lot about Neil Gorsuch's opinions at the federal level, and both rest on the idea that the legislature is a key embodiment of the sovereign will of the people, and so therefore there are both delegation and I don't know how to describe. I guess their continuing surveying of administrative behavior is important because it reflects important democratic principles. Legislatures are democratic. As I look at Wisconsin's legislature, I'm not sure it's democratic, right? It's heavily gerrymandered. It's not representative of both racial and other types of minorities. And indeed, throughout the crisis, it has not really met to effectively manage the crisis, right? And so when we think about structural legitimation, it forces us to think, is the legislature acting in a legitimate manner? And I think one of the things that we have to address in this particular crisis is the conundrum of the legislature, right? What happens if we have a legislature that is not acting in a democratic way? And whether or not simply asserting that is necessary. So I guess I am much like the unnamed Wisconsin Supreme Court Justice Rick, that I don't think it's merely enough to state what the legislature should normatively be doing, but I also think there has to be practical consequences to empowering the legislature to act in many ways as a check on the administrative agency. And I think that's a fundamental project that we have to begin to think about. Finally, I think it's very important to understand that even within a structural legitimation argument, Wisconsin has had a tradition of both thinking about this relationship in a fairly sustained way. And when I talk about that, I'm talking about the existence of the tradition of what Wisconsin calls core powers of the legislative, executive, and the judiciary, and what Wisconsin refers to as shared powers. So such set of circumstances in which the legislative, executive, and judicial share power in order to create a more effective legal regime. And I actually think administrative law and the types of choices that we've seen in the public health crisis are indeed a function of Wisconsin shared power, a specific way in which Wisconsin law has tried to, I think, build in flexibility to manage circumstances that we see within COVID-19. And I, as I reviewed both Palm and Tavern and a number of the other cases that mention it, we see some mention of the shared powers tradition. A footnote, there was Rebecca Bradley had a fairly devoted a paragraph or two to shared powers in her determination or in her decision in Palm. And I guess for me, I think we needed to have a little bit more conversation about that particular tradition, the ways in which it might help us regulate, right, during a public health crisis, which I think because we have been in such a sustained argument during the public health crisis about this question of structural legitimation, that we may have lost, I think, some practical focus on the types of issues that Wisconsin citizens need to be addressed, particularly in a public health crisis. So I thank you for this opportunity, and I look forward to question and answer.
All right, well, first off, thanks to all of our panelists here for giving us a lot of food for thought. And I think we'll have some good back and forth here with our panelists in terms of, what are the issues at stake and what government powers can be implemented here and what the limits are on that. Maybe here at the outset, just to kind of tie together some of these initial comments, as we think about structural limits when it comes to these questions about policymaking during a pandemic. And as we think about this question of separation of powers versus shared powers, and any, I guess, initially any responses amongst our panelists, and in particular, what about the fact that if as we see in a number of places nationwide, if we have gerrymandering in a legislature, how should that affect how we think about the structural limits, separation of powers versus shared powers? Any thoughts from our panelists on that kind of initial idea, which I think ties together what multiple panelists were talking about here?
I think Kaylee laid out quite well, debate that we've been having ever since the dawn of the progressive era about expert legitimation versus structural legitimation. Although these cases played out with that debate operating in the background, because in none of these cases did the Wisconsin Supreme Court find that there was a violation of the state constitution. In all of these cases, the court found that the statutory framework that had been put in place had not been followed, either because there had not been rulemaking in the case of the initial or the extension of the stay-at-home order in Chapter 252, or had not been, or the governor was not empowered to declare emergencies in series under Chapter 323. Now, to be sure, there were people, and I was one of them, making this argument in the background that you must interpret the statute this way because you must practice the doctrine of constitutional avoidance or constitutional doubt. That is, if you were to read these statutes in a way which provided this measure of power to DHS, or this a measure of power to the governor to declare emergencies in series, that you would create a non-delegation problem. The court never addressed those things. I think a couple of the justices suggested that yes, they were indeed worried about those things, but we never got to any of those questions. If we had gotten to those questions, then I think some of the issues that, Kaylee in particular pointed to would have been presented in really interesting ways, because it's not clear that Wisconsin even has a non-delegation doctrine. That is, the Wisconsin Supreme Court has suggested from time to time that legislative, oversight of rulemaking is itself a sufficient and adequate structural safeguard against the abuse of administrative authority. I'm not sure that's true for a variety of reasons, and one of them is concerns that are raised by the ability of a subsequent legislature to countermand without, presentment and signature, the acts of a prior legislature. But at least so far in these cases, those issues, those constitutional issues, haven't been litigated and resolved.
I'll step in here just for a couple of quick comments. For our audience, one thing our audience should know is that the separation of powers regime in Wisconsin is unusual to the point of being unique. It is among the most fluid of any state system in the country in terms of the ability of the executive and legislature in agreement with each other to pass powers back and forth. Well, sometimes in agreement and sometimes not. That was discussed at some length in earlier cases having to do with, for example, the legislature taking powers away from Governor Evers when he was coming into his office. One of the questions was whether certain powers of the Attorney General, as Kaylee says, were core powers, which could not be shuffled back and forth, and which other powers were shared powers. But it's worth knowing as background that Wisconsin's situation is really quite unusual in comparison to other states in terms of the amount of fluidity that is allowed. And for that matter, the scope of the executive veto historically, for example, is extremely broad in Wisconsin, which is just another version of the same thing. A second point on what I think Rick is talking about, both Rick and Kaylee have been talking about, is Rick raised the point that part of the political pressure on the governor to act was that the legislature wasn't doing anything, right? And the justice asked Rick, apparently, doesn't the legislature's inaction indicate acquiescence? That's not a new argument. The U.S. Supreme Court has made precisely that argument, cases like Dames and Moore versus Reagan, just to throw out a name that my fellow panelists will know, that where the legislature has acquiesced to executive action, that counts as agreeing to it, has failed to object. That counts as agreeing to it. I mentioned, again, that only as background, but there are different ways to thinking about this question. And more generally, and this gets back to Kaylee's point, one of the assumptions in our discussions of separation of powers is that each branch is functioning. So if we join Justice Gorsuch in saying it is a fundamental aspect of the sovereign will of the people that legislatures have control over policy, that assumes both that we have some degree of faith that legislators reflect the people and that they're undertaking to reflect that will in some ways. One of the really difficult problems for a separation of powers analysis is what happens if, for whatever reason, one branch of the government becomes non-functional, or, to borrow Kaylee's point, illegitimate. As a philosophical matter, that gets to the heart of why these law of democracy issues like voter suppression and gerrymandering are so troubling, and why it is so troubling that, as interpreted by the U.S. Supreme Court, the Constitution gives us so little to work with to respond to those concerns, because they undermine the assumptions that make all the rest of the system work, starting with the assumption that representative bodies are in fact representative. But as a more practical matter, coming back to Rick's self-characterization as a lion litigator, which is a considerable understatement of Rick's role. But coming back to that description, what happens to our analysis, our nice theoretical analysis, if one branch or the other has simply stopped working and there exists a genuine emergency? That was the kind of argument that used to be made by people like Hamilton for the need of an energetic executive that could step in and take immediate action and so on. But it's an ongoing, as everyone has said accurately, it's an ongoing debate. That particular aspect of dysfunction, though, I think is a relatively novel element in the discussion, and one certainly I have not seen discussed at great length in the historical literature.
So the first response that I have is to Rick's sort of discussion of what the stakes of at least Palm were. I mean, I think we're going to end up seeing Palm as a fairly important decision in Wisconsin law. And Rick, I think, correctly says this is really a case about whether or not this was a rule, a type of a rule that had to be issued by an agency, or an order. And again, I mean, I have to say, I found Justice Hagedorn's opinion, his dissent in Palm, persuasive, that this was not a rule. This was not a rule. It was an order. And I found Justice Hagedorn's decision persuasive because it really, I think, as a statutory interpretive matter, I think understood the goals and purposes of the different types of administrative behavior listed in Wisconsin statute annotated section 227. I found it persuasive on that point. As to the second point, I've thought a lot. I'm teaching administrative law now, and when I went to law school in administrative law, we did not talk about the Constitution at all. We talked only about expert legitimation as exemplified by the Administrative Procedure Act. And when I started teaching administrative law again, when I started teaching it, one of the things I had to significantly adjust my syllabus for was the emergence of structural legitimation, and in particular, I think the increasingly important role that Justice Gorsuch is playing in administrative law generally. I call him punk rock Neil Gorsuch, because he is, in many respects, really, I think, pushing administrative law to ask interesting questions about the function of legitimation in its system. And what I have at the same time noticed is that we are in an era in which the administrative law of elections is more important. And the question of as Howard puts it, what do you do with a dysfunctional legislature? It's not only relevant in Wisconsin, it's obviously relevant currently in Congress, where the only way we apparently are able to pass laws is through the budget reconciliation process, right? And I think in many respects, this is like, whether you are liberal or conservative, this is a profound problem in our democracy, that we've set up our legislatures not to actually function, right? That we have placed, and in fact, our legislatures increasingly reflect racial polarization, geographic polarization, and other types of polarization that make it an incentive not to do anything at all, to keep the status quo, even when we're in the middle of a major pandemic and we need the legislature to do things. And I think as we think through structural legitimation, we have to confront that problem, because I think that the dysfunction of legislatures, and you can be just as dysfunctional as a Democratic legislature as a Republican legislature, the dysfunction of legislatures pose a profound challenge to the understanding of administrative law that is based on this separation of powers idea.
All right, well, any other thoughts on that question before we?
I mean, I thought that both the governor and the legislature were sort of dysfunctional through the course of this pandemic, because call me old-fashioned. I know I've been around for a long time, but I used to remember this thing where if the executive branch and the legislature were at odds with one another, that the solution of it wasn't for both sides to go off into their corner and pout about it, or make noise on cable news. That there was this perceived obligation to sort of move and try to compromise. And we never really saw that attempted here, with both sides sort of blaming the other for being obstinate before we even had a chance to find out who would in fact be obstinate had the process gone forward. And I sometimes I think that legislators have gotten this way in part because of the growth of the administrative state and the increased willingness on the part of legislators of both parties, really, to simply enact laws which express some sentiment, allow the executive branch to go off and make all the hard decisions, while they act almost as if outsiders whose principal job is to comment on this, rather than people who themselves are responsible for crafting the law. I don't know what the solution for that is, but I do think that what happened here in Wisconsin was at least in part an example of that type of thing.
I have to say I agree with that description. Multiple elements of that description. It poses a question even broader than the one Kaylee has raised, which is the current separation of powers based model of administrative law, which focuses on things like deference, delegation, distribution of authority, simply obsolete? Do we need to rethink the entirety of the model in response to the fact? And as I say, I agree with Rick's description about what happened in Wisconsin. More generally, it's a theoretical question. What happens if a branch becomes dysfunctional, which is not made better if both branches become dysfunctional? Doesn't reduce the problem in any way, given that there's a need for government capacity and government action at times, and that the failure to take any kind of action is itself is a fundamental, as Rick said, there used to be a sense of responsibility to come out of your corners and do something. And so it's just one more of those places where that kind of soft power, hard to quantify questions of political culture and norms, right? Again and again in the last 5 or 6 years in particular have been shown to be so important, because ultimately even something as technical as administrative law depends on them.
I think there's, usually two responses, right? The first is, I do think that increasingly we're having to address how does a broader politics of polarization impact day-to-day administrative law. And I think of public health as sort of paradigmic administrative law, right? It's a subject of expertise. There are established facts that individuals need to accept, and there may be a need for sweeping action in response to a swift emergency. And if we already have a baked in polarization, and Wisconsin's pretty much like, ground zero for baked in polarization around politics, it makes it very difficult to administer, right? That because there is a lack of trust and there is a lack of legitimacy in the political institutions of the state as a response. And so the question then becomes for politicians, well, how do I begin to think about acting, right, within the context of that polarization? What are my incentives as a politician to try to overcome that polarization? Or what is my incentives to accept the polarization and attempt to govern in face of that polarization? And I think you're seeing that question both by Tony Evers or I think Joe Biden, right? They're going to both have to address that question. And the question then becomes, well, how do you lessen the polarization? Because obviously that would be the ideal outcome, but I don't necessarily think that politicians themselves are incentivized to lessen the polarization. Like that has to be a set of choices made by, I think, broader democratic institutions that think through that polarization and whether or not it's functional on a day-to-day basis, and indeed whether or not it interferes with the task of the state.
Well, and I think in some ways this might be a good lead into one of our questions, and this question of polarization here. As one of our questioners notes here, when you look at either how quickly states acted when perhaps they could have acted more quickly, or how quickly the federal government acted, and coupled with the fact that there are other potential pandemics could be on the horizon, questions about climate change and dealing with issues related to that. How does our system cope with this if we have such polarization? Is there an answer there? I mean, the easy answer is, well, Congress or state legislatures, they pass something into law, something gets done, right? But if we have this level of polarization, both at the state level and the federal level, and we have these significant threats to public safety, to public health, is there some sort of answer that you would have in terms of and maybe this, Howard, this goes to your point a bit as well, as far as reconceptualizing how we think about this from a much larger systemic level? Or is our system designed to deal with this? Are we going to be okay, given that our system was designed at a time when, especially at the federal level, but certainly also at the state level, when governments had to deal with natural disasters and pandemics, and is that kind of baked into our system? I know it's a long and rambling question, but not on the part of the questioner, but me in terms of describing it. Any thoughts here on kind of what the answer is to deal with what I think each of you has identified as a problem for why things haven't been working the way they have, but then what's the answer to that?
Let me give three really quick answers, and I'm only jumping in to go first because I expect to be quick, uncharacteristically. One, a number of very good administrative law scholars, I'm thinking of Ed Rubin, for example, at Texas, have written really interesting explorations of what a different model of administration might look like. And I will defer to Kaylee to talk about some of these models, but the entire concept of separation of powers is, right, of course, a version of checks and balances based on the idea of aggressive government entities trying to seek control over policy. It just doesn't work very well if they lack either the capacity, as is often the case, or the will to have, as Rick pointed out, to have any kind of direct control, and particularly if they find it politically advantageous to leave these questions to the agencies and thus not take responsibility for the outcomes. That tends to lead to a breakdown of the entire system. So rather than thinking of administrative agencies and the administrative state as something caught between these two branches, we might take a lead from Wisconsin's structural design and think about it as a fourth and independent branch with a whole set of internal constraints of its own, not dependent on getting cooperation from elected officials. Second, I don't think you can overstate how much polarization in our politics is a result of structural factors like gerrymandering. Not only that, but that's such a huge one. That leads, as political scientists have observed for decades, to ever more extreme candidates being elected because in a gerrymandered or a safe district, it's the primary that counts. And of course, you win the primary by appealing to the most motivated, which usually means most extreme voters within your party. There's a whole long story behind that, which I don't need to go into unless somebody wants to. But for the moment, recognize that to a great deal, if you look at polling data on any issue, it is not in fact the case that Americans are that deeply divided and polarized on policy questions. They're that deeply divided and polarized on identification and their mistrust of each other. But on the policy questions and the getting things done, decision-making kinds of questions, it's the representatives who are polarized to a far greater degree than the actual voters. And that speaks to a fundamental dysfunction in the electoral system, which can't be addressed as a matter of administrative law, but just points to how all these things lead to one another. And the third really quick comment is, there are a lot of folks who spend their lives as political scientists studying constitutions and constitutional democracies who are not sure America is going to make it because there's a cliff you can go over where words lose all their meaning, where we don't have any shared knowledge and understanding, where we fundamentally hate and distrust each other. There's a point of political culture. And if you can't get back from that point, there's no guarantee that the system continues to work. And I think that administrative law, interestingly, is really a kind of canary in a coal mine on this kind of question, because it's not the place usually where the most strident ideological debates come to the fore, but it's the place where any kind of breakdown in the functioning of the system shows up first. So those are my three quick, if not necessarily pleasant thoughts.
Well, so there's a couple ways that I think that we can think about, well, how do you manage a polarized environment? And I have been doing a lot of thinking lately on Reconstruction, both why Reconstruction really is the emergence of a modern federal administrative state. The Freedmen's Bureau in particular thought to have a multiracial structure, and it had a very wide sweeping administrative grant. And I thought a lot about redemption, right? The failure of Reconstruction and the sort of racial terror that was left in its place. And I think it's important to think about that moment because the political culture that came out of both Reconstruction and redemption has in many ways cast a long shadow over our country. And so we have to think about, we actually did fail, right? We did fail as a political culture. We had a civil war. And we have to think through the sets of questions that Congress from 1861 to 1865 or even I would say 1876 had to think about, like, what are the choices that we have to recover and to think about a culture, a multiracial democracy, and it failed, right? So we're in the second the third reconstructive moment where we're a multiracial democracy, and multiracial democracy, as Howard notes, is really hard. It is there is a reason why we don't have long stories about multiracial democracies, because in many respects, it's very hard to overcome, again, polarization around geography, polarization around race. And so we have to be very conscious about thinking about it as a fundamental problem of the American state in general, that what we have actually in America is, polarization as a norm and brief moments when polarization goes away. And so we have to think about how we extend those moments where polarization recedes, right? And we sort of see a key moment between the 1930s and the 1970s where we have the New Deal era, and polarization receded both in the political parties as well as within the larger culture. And we have to ask ourselves what was crucial about that moment, and what were the mechanisms that helped Congress in the United States reduce polarization for that moment. And I think we have not given enough credit for the New Deal and the folks who were authoring the New Deal about the way they designed federal programs to be inclusive, right, to a wide range of individuals, and the ways in which they sort of thought about what I call opportunities for conversation within a democracy through things like the Works Progress Administration and other types of places in which the government actually said, we're gonna have conversations every week. We're gonna have a fireside chat. that help people to think about themselves as part of a shared endeavor. And I think one of the real problems of the moment is that we lack a sense of shared endeavor. We lack a moon race, and we lack, right, a place where Americans can come together and decide that what we are proud of as a country is things that we do as citizens. And so I think about this polarization a lot. I see it in my law students. I see it in the communities that I belong to. And I think that we have to become much more intentional about saying to each other, right, what is our shared endeavor? You know, and and again, Wisconsin obviously is a key place where there has been a political conversation around a shared endeavor. And I do think it's very important to have sort of a discursive moment where we say that polarization is not helpful, nor is it functional. And I can see, I mean, I think in many respects, this is why Joe Biden was able to sort of overcome the incumbent advantage. I think he has a relatively neutral personality. And so people can map that conversation on him. But I do see it, I agree with Howard. I do see it as a fundamental problem to American democracy. And I think we need to be much more self-conscious about it.
You know, I think that those are all great points. I think that a lot of this problem is resistant to policy tinkering, right? I mean, empowering a fourth branch of government is not going to make polarization go away. I think would exacerbate it. You know, we can debate the extent of gerrymandering, but I think there is an underlying reality here, and that we have increasingly sorted ourselves by population, such that it's not surprising to see some of the results that we do. I do agree with Howard that we are probably polarized by identity more than policy differences, although capturing policy differences by polling is very, very difficult. And I think the reason that we're polarized by identity is that we have tended to see we've tended to see our identity as being at stake in the resolution of every political question. They are all now seen as existential, right? It's either the Flight 93 election or disagreement about whether we have 2 or 3 weeks of early voting is characterized as Jim Crow. And I think until we learn to stop essentializing every problem like this, this polarization is not going to go away. And I don't know what you do to solve that problem. I don't know if it's a product of the fragmentation of society that is brought about by social media. I mean, when I was a kid, I mean, there was kind of a common American culture. We all sort of consumed the same information. That is definitely not the case anymore. We want to live in our own little world where we hear only what we want to hear. It is perfectly possible to do that in a way that it probably wasn't, 30, 40 years ago. And so I think that what makes these problems more fundamental and difficult is that it's not clear that there is a solution from above. The solution is from below.
Right, well, we do have a question here as well about a branch of government we haven't talked a lot about at this point, except for the decisions it's rendered, which is in the third branch and the courts. And in particular here with the state Supreme Court, a question here from one of our attendees about the length of time that it took for the state Supreme Court to issue its most recent decision here on questions about government power during the pandemic. And the questioner wondering if this was delayed to wait until circumstances had improved with regard to the pandemic, or if any of you have any insight into that, kind of why you think it took the length of time that it did for that decision to get handed down. I'll toss that out there. Maybe we don't have opinions on that, but if we do, that's what our questioner is looking for.
Well, maybe you can count on a line litigator to cravenly defend the court, but the Palm decision proceeded at rocket speed. I mean, that went from filing to decision in about a month. We filed another case called we call it W. Chris, but it was 3 consolidated cases that had to do with the public, the ability of Dane County to close private schools. And within a couple of weeks, the court issued a temporary injunction ordering the schools to be open. Right? It hasn't resolved the case yet. It was argued in December, but the court acted very promptly. The Fabic case took a little bit longer. Right? The case was, but even then, what we have from November to today, to April, in terms of the time from argument to decision. But remember, they took that as an original action. So the case was filed in October, and it maybe is hard for non-lawyers to understand, but this is really, really quick. And I think one of the issues that we're seeing with the court right now is that the pandemic has placed it under a great deal of stress, where litigators like me were filing everything as original actions. In fact, the one time I didn't, they granted the original action, like leading me to conclude that I probably should have, gone to that well one more time. But I think that there has been sort of a robust division on the court. I think it takes time for opinions in those circumstances to write. So I wouldn't, suggest any type of grand motivation on the part of the court to delay something until they thought it would go over better. I just don't see a consistent pattern supporting anything like that.
All right, any thoughts from our other panelists? Or
Not really on this question, just that, the wheels of justice grind slowly. But as Rick pointed out, they grinded pretty fast this time.
Well, and I know we've had some questions here in particular about structural questions, and we talked about a number of structural issues here. But we've also heard a couple of times about Jacobson versus Massachusetts, and getting into questions here, either questions at the state level in terms of police powers, or what might exist in terms of perhaps constitutional liberties questions. So any thoughts in that regard? Can the government, whether we're looking at state government or federal government, can they require vaccinations? Can they require vaccine passports? We're kind of at that stage now in the pandemic where questions about vaccines have come to the fore. What are our panelists' thoughts in that regard?
I think Howard correctly notes that when the government is acting in its public health capacity, the government is acting at generally what is understood to be its highest authority. Now, I think we're seeing a number of decisions by the Supreme Court, by the federal Supreme Court, that when we look in particularly at issues of religious liberty, I think this court is a court that will definitely scrutinize public health orders that may impose restrictions on fundamental rights, in particular the exercise of religion. And so, I thought Rick was smart. You don't fight the government on its public health authority. You fight it on the statute, the ways in which the government expresses its public health authority, because if I think Rick had mounted a direct challenge to these provisions, I think it would have been a loser as an ex-line litigator. And so I think that strategy is very important, how you bring these set of cases. And we have, as Howard points out, in Wisconsin, a really significant history of public health orders and the scope of public health orders. And I think when the government acts in a public health crisis, we both have a state framework that grants states significant police power, and then we have a federal government framework that is a multi-agency framework, both with the Department of Health and Human Services, as well as the Army, as well as other major administrative players. And when they're acting in the scope of that authority, it's been delegated quite broadly, because I think the best way to think about public health, it is, I think, in many respects, a paradigmic area in which agencies act on expertise, right? And I think when we think about modern regulatory regimes, many of them start in public health. Our earliest vaccine case is 1852. And in that case, the government was giving sweeping powers to vaccinate school-age population. And so I think when we have talked about the COVID-19 crisis, it's been interesting to me to see so much conflict over the crisis, because when we think about it, when the government is acting in its public health capacity, it's often acting at the zenith of its administrative power. Is it the zenith of the height of its administrative power? And so, yeah, this has been an interesting set of cases.
I think I agree with you that any well, first of all, as a fully vaccinated conservative, I'm not looking forward to any kind of vaccination cases whatsoever. But I think that you're right in terms of that if there is litigation over mandated vaccination, which I don't think we're actually going to see, or vaccination passports, which I also don't think we're going to see, except perhaps in the context of a legislature that forbids them, and in which case I don't know that can be effectively challenged either. But if there is such litigation, it will be most successful if there's some kind of religious liberty claim. If you simply go in and say, I don't agree with the assessment of the government with respect to the safety or the efficacy of vaccines, I think that probably would be a loser under those circumstances. But part of the problem, and one of the reasons that I think that these issues have become salient, is that not every question here turns on the application of expertise. Expertise informs the decision, but the decision itself involves the balancing of competing values. And I think one of the reasons that there's been public reaction to this is at least some people believe that at least their assessment of how the competing values balance out is being ignored.
Yeah, I don't have a lot to add, actually. I agree with all those comments. At the moment, religion and assertions of religious exemptions are the biggest doctrinal basis for challenging state action. I think both of my colleagues are right. As a general proposition, government's authority to engage in public health measures is extraordinarily broad. It is indeed the zenith of government authority, and the most traditional, the longest recognized. It would be a radical change to say something like government is obliged, not maybe, but is somewhat constitutionally obliged to balance economic costs against public health. Something like that would be a truly bizarre departure from anything we've ever had in our constitutional doctrinal history. It's worth pointing out that the religion question is very much in flux. This court is the most sympathetic to religious claims of any court possibly in our history, certainly in the modern era. And what's problematic for those of us who try and read the tea leaves and figure out what direction constitutional law is developing is that most of the decisions about, for example, religious objections to closing orders, just to take one really obvious example, have been decided through what's called the shadow docket. There haven't been opinions with explanations. There haven't been constitutional arguments. There have been injunctions granted or denied. There have been orders entered or stayed. So it's really a strange situation. I don't know a comparable one at any period where the Supreme Court is clearly remaking a really critically important area of doctrine. What's the balance between assertions of a prerogative of a religious person not to be governed by the rules that govern everybody else versus the public interest in having everybody be governed by the same rules, right? How is that balance to be struck? That very core First Amendment question is very much in flux, and it's in flux in a way where all we can do is count outcomes, because there's if you remember the case Masterpiece Cake Shop, the one about the baker, which has got a lot of attention, it actually didn't decide anything. And so we have a lot of opinions and we can make guesses, but we're kind of at this point waiting for the Supreme Court to give us some guidance as to what this new balance is going to look like. But other than that, leaving that issue aside, it's a big one, but leaving that large issue aside, yeah, I don't think any general challenge to the authority of government at some level, and state versus federal is a whole different issue here, but of government at some level to impose restrictions in the interest of public health, I don't think any such challenge makes any sense.
And of course, there is a case in front of the Supreme Court right now where they could be giving us a different standard for religious liberty, where the Smith decision especially for those who are in attendance who are my students, they know Employment Division versus Smith is the current that is potentially on the table here, right?
It maybe it can also be decided in a much narrower range of the Fulton case, I assume.
Right.
But there've been half a dozen. The California closers case could have resulted in an opinion that discussed the issues we're talking about and laid out a framework for thinking about it and gave some guidance to legislators. Instead, it was handled in the shadow docket. It was handled in the entry of an order with no written explanation or opinion. If you really want to mess with your students, you should share with them the most favored nation theory of Smith, which Gorsuch, among others, is very fond of.
Well, if it weren't so late in the semester, I don't want to torture them too much.
No.
Well, that exhausts the questions that we have here from our audience members. Before we close here, any final thoughts here from our panelists?
Well, I saw a question, if I may,
sure,
which goes, should there be a state of emergency policy change to address the exceptions needed for a pandemic? I want to take the first half of that question and ignore the second half because I can. Is there something wrong with the way in Wisconsin or generally, but let's start with Wisconsin, state of emergency issues are handled? And I would say one of the lessons from this experience is, if you have a system set up, and I must say I approve of the idea of a system that requires back and forth between the governor and the legislature. That seems to me sensible on multiple grounds. It seems to be consistent with fundamental notions of checks and balances and separation of powers and democratic input, all sorts of reasons why I approve of that idea. But I think there has to be a measure in place for what to do if one branch or the other simply doesn't do anything. The default state cannot be, therefore nothing can be done. Because some situations, I'll go back to Alexander Hamilton, are genuinely emergencies and genuinely need action.
I mean, I like Howard's idea a lot. I think sort of thinking through consultation and requiring consultation as emergency orders are drafted might be a good way to frame the conversation between the executive and the legislature over the scope of emergency powers. We use and again, if we're thinking about something that reduces polarization, requiring a consult might be a way to reduce polarization, right? Instead of imposing a time limit, impose a consult. And I think that might be a way to frame the conversation a little bit differently. I mean, I think one of the questions that I think has arisen, if the legislature refuses to meet to issue an emergency order, what is the executive supposed to do in that instance is a good question. Because at some level, if the legislature is refusing to guide, if they think it is important to have guidance, they must, I think, come together and engage in that particular process. And we do have some statutory requirements in Wisconsin that the executive and the legislature consult. The other would be, I mean, I hate to say this because it sounds dorky, but I'm an administrative law scholar, is create a commission. And the commission makes a recommendation to the legislature as to what the best set of goals are. That's another way of reducing polarization, right? Because nominally, the executive and the legislature could name people to the commission and they could actually go about designing an emergency procedure process that takes into account liberty and trust. And again, we have in a polarized politics, we sort of see these types of depolarization, lowering the temperature administrative vehicles as bad because you're somehow corny for thinking that politics are effective, but commissions work for a reason. They work because legislators don't always have time to go through the type of detail that you need to do in order to enact a fully useful law. They can hold hearings, right, where a range of parties speak, and then they can come to a set of solutions that may not be ideal for everyone, but can indeed, I think, guide it in the future. And so I think we can think of a lot of different mechanisms to reduce tension between the legislature and the executive in order to effectuate, I think, a fundamentally good emergency power mechanism.
I think 323 is to some extent, as it's set up now, is a mechanism to force consultation. That is, the governor gets 60 days to take emergency action. The legislature can extend it. The legislature can rescind it. And, one can claim it's dysfunctional that the legislature didn't act on its own. But the fact of the matter is that under the politics of the moment, the legislature was able to say that it preferred local solutions, or it was not going to impose a statewide set of rules, and it didn't pay a political price for that. And perhaps it would have paid a political price had the governor forced the issue, but the governor, for whatever reason, decided not to force the issue, and he didn't pay a political price either, as near as we can tell.
But see, in a sense, that's the problem. Everyone should be at risk of paying a political price. That's what accountability is all about. And a system that permits that to be completely evaded has a problem.
I'm not sure it's the system that permits it. It's the polity that permitted it.
Well,
Gerrymandered polity that permitted it. I'm just going to point that out there.
I mean, I want to actually push back on something Rick said earlier, and then give
I don't entirely agree with that.
Right. I want to push back on something Rick said earlier, and then if I may give him the last word to respond, if that's a permissible way to proceed here. Which is the point that was just being talked about, the top down versus bottom up. Time and time again, when we study around the world situations of conflict, there's always a narrative that says these are deeply ingrained oppositions or conflicts, and it's all grassroots and nothing can be done from the top down. But then you study it and you discover that people have deliberately ginned up these conflicts. And that in many cases, they didn't exist until somebody invented them for their own purposes. And you also find that they are enforced and reinforced by structural elements that make it advantageous to pursue nihilistic conflictual behavior. And you also find, whether it's in Latin America or South Africa or in the Balkans or in Europe, that attempts to use political mechanisms for reconciliation and consultation can be highly effective. So I really don't buy the argument that these kind of polarization that we're talking about happens organically or naturally or inevitably. In every historical instance of which I'm aware, a close examination makes it pretty clear how it happened, and that it was not by any means inevitable nor insoluble. Rather, it's a matter of interested actors making use of institutional incentives and opportunities to pursue certain goals. And Rick, I would like to give you the last word to respond to that if you want to.
Well, I mean, I don't know that that a commission, for example, wouldn't leave us in precisely the same position that we're in today, because there would once again be disagreement as to how the legitimacy of that commission is going to be established. I don't think that there's any way out of these problems other than to return to those hazy days of the 80s when we debated politics vigorously, but we thought that we had a common investment in a set of rules, and that we weren't in a situation where it is considered a sign of weakness for people on the Democratic side or the Republican side to insist on some measure of procedural regularity and consistency. this is weakness. This is largely derided by the extremists in both parties as weakness and as giving in to the other side, because we know that if they have power, that they will abuse it. Therefore, we should abuse it as well. And I have to tell you that that is one of the most frustrating things that I find about the public debate today.
Well, we will have to leave it there, although I think we could have gone on for another hour or two with the great back and forth here we've had with our panelists. I want to thank Howard Schwaber, Kaylee Murray, and Rick Esenberg for their expertise and their insight here. I also want to thank our co-sponsor, the Center for the Study of Liberal Democracy, especially Kari Zarecki, Scott Mobley, and Rick Avramenko. And at our own Menard Center for Constitutional Studies, I'd like to also thank Carla Hillestead. And thank you, of course, to our audience members. We hope you gained some new insights into these major questions. And if you are free, you can join us next Wednesday at 3 p.m. for a student speech on social media panel, which will be looking at a case just argued today in front of the Supreme Court about the rights of students to be able to post on social media. And if those students are in public schools, what kind of protections they have under the First Amendment. And more information can be found about that if you follow the Menard Center for Constitutional Studies on Facebook or on Twitter. You can figure out how you can register for that panel or follow other news that we have about the state and federal constitutions. And with that, again, thank you all.